Hey, this is Trent Cotney, CEO of Cotney Construction Law. We're here with another episode of Law and Mortar. And today we have Justin Hampton with us. He is the head of our North Carolina office in Charlotte and been practicing for 8+ years. Yep. And former DOT lawyer, so he knows a few things when it comes to DOT. And one of the things that we want to talk about today is kind of tell you a little bit about how North Carolina law differs from some other states. Obviously, we practice all over, and every state has their own rules when it comes to construction. But one of the interesting things that I heard you talking about the other day was that in North Carolina, there's not only a lien on the property, but you can actually lien the construction proceeds. Why don't you tell them a little bit about that?
Yeah, so in North Carolina, we have two types of lien. As Trent just mentioned, we have what's called a lien on property, which everybody's familiar with. We also have what's called a claim of lien on funds. I'm a guy who likes to use examples, so I'll give you an example to illustrate what a claim of lien on funds is. If I'm a first-tier subcontractor, so I've contracted with the GC, and the GC is not paying me, as happens far too often, I can serve a notice of claim of lien on funds to the owner, and what that does is, to the extent the owner still has money he owes the GC, he can no longer pay that money to the GC until I get paid. In the event the owner goes ahead and pays the GC, then he becomes directly liable for the money that I'm owed, even though we don't have a contract. So it's a tool that can be very useful to subcontractors in particular in getting paid on jobs.
Yeah, we need that in Florida. Yeah. that would be good to have. So the next thing that I think is real interesting about North Carolina is, obviously we do a lot of OSHA defense all over the U.S. North Carolina is a state-sponsored plan, and while a lot of the things are similar to federal, there are some unique things when it comes to timing and the way that they handle, the contest period. Why don't you tell them a little bit about North Carolina?
Sure. As Trent mentioned, North Carolina is a state-sponsored plan. North Carolina, for the most part, has adopted the federal OSHA regulations. There are some key differences with deadlines. For instance, whenever you receive a formal citation from OSHA, you have 15 days to either contest it or to either pay it, or you can file for a request for an informal conference. In North Carolina, if you request an informal conference, you essentially toll those 15 days. So you have your informal conference, and then you either settle it, or there's no modification to the citations, or you reach some other type of agreement. Regardless of what it is, you'll get an additional notice from OSHA given the outcome of the informal conference, and you get an additional 15 days after that to contest it if you're not satisfied.
That's interesting. So that's a lot longer than the federal period, because under federal you get 15 business days, and you got to do your informal during that time period, and then you're cut off. You got to do your notice of contest within that time frame. So that's interesting. And one of the things we always say is it's not necessarily the money part that you got to look at on the citation. It's the classification and the chances for repeat, because there's a good chance that if you get hit once, OSHA's going to keep coming and finding you again.
Exactly.
So last thing I want to talk to you about is that you've had a real interesting background in working for the DOT. You got to see things firsthand. I know a lot of contractors and trades out there, trying to navigate DOT regs is difficult. I have a tough time with it. So, when you end up in litigation with DOT, I know enough to know that there's a lot of different hoops you got to jump through. Why don't you tell them a little bit about what your experience was firsthand working for them?
Sure. Worked for DOT for about 3.5, 4 years. Got to see a lot of claims come through during that time. Whenever you have any type of action against DOT, it's very procedure driven. There's a whole administrative process that you have to go through. You have a lot of deadlines that are key to final acceptance of projects, when things are done. And it's very spec and statute driven. And so whenever you're just working with DOT, you want to make sure that you have an attorney or you have counsel that can be very aware of those deadlines, the procedures that you're going to have to go through. You can't just go out and sue DOT like you can a different corporation or entity. So that's something to keep in mind, that it's very, very statute driven.
Yeah, it's difficult stuff, so you really got to know what you're doing. Justin, I want to thank you. If anybody out there has any questions relating to North Carolina law, Justin's your man.
I'm your man.
So we appreciate you. Stay tuned for more law and more in the future. Thanks.